In this video, we're going to be looking at some different types of trust. Now, before we start, I just want to mention that this is just an overview of some different types of trust, and in a later video or in some later videos, I will be looking at these different types of trust in more depth, but it's really more of like an introductory video for people who are studying equity and trusts, just to get a more general overview of the different trusts that are available. So let's get straight into it. The express trust. Now, a trust is an express trust where the settlor has expressed his intention to form a trust. Although there is no requirement to use any particular form of words, the intention must be clear. So, express trusts are trusts which are declared intentionally by the settlor. The most common example is where the settlor, the owner of the property, transfers property with a declaration, whether written or oral, that the transferee, i.e. the trustee, is to hold the property on trust for the benefit of the named beneficiaries. So typically the settlor will intend to settle specific property on trust for clear, identifiable beneficiaries to be held by appointed trustees according to the terms set out by the settlor. However, there are situations in which the settlor might intend her actions without knowing that a lawyer would define those actions as constituting the creation of a trust. So, for example, a settlor may intend both her children to have equal access to the money left in her will without knowing that a lawyer would say that she had created a trust over that money in favour of her children. And in such situations, the court will find that an express trust has been created. The owner of property may also declare that they hold property on trust for another without transferring it to a trustee. So in the case of Hunter and Moss, Moss, the owner of shares in a private company, declared in the course of a conversation that he held some of his shares in the company on trust for Hunter, one of the directors of the company, and that trust was upheld by the court. Okay, so that is the express trust. Then we also have the constructive trust. So a constructive trust is a trust implied by law when the circumstances are such that the conscience of the legal owner should be engaged. This may be, for example, where money is paid by mistake. The person who has the money will hold it on trust for the money who paid it. So in circumstances in which a defendant has acted unconscionably, for example in keeping a payment which she knows was paid to her by mistake, the court will consider the defendant to be a constructive trustee. There are other contexts in which the court will analyse the situations as giving rise to a constructive trust. In relation to family homes, where two or more people come to an arrangement as to the ownership of their home, the English court will typically impose a constructive trust on those parties to give effect to their common intention. And we did look at that in the videos on land law. So if you haven't checked out those videos, I would check those out. And that does explain the common intention constructive trust and trust relating to the family home, for example. And then we also have resulting trusts. So resulting trusts are implied by the courts too. They are not created intentionally by the settlor. So a resulting trust may arise in two circumstances. Number one, where a settlor has transferred property on an express trust, but the trust fails. The objects are never determined, or there is a surplus which cannot be used for the objects. In this case, the trustee will hold the property on resulting trust for the settlor. So where the settlor has transferred the legal rights in the property to a trustee, but has failed to identify the person or persons who will take the equitable interest in the trust property, that part of the equitable interest which has not been settled on trust for an identifiable beneficiary will be held by the trustee on resulting trust for the settlor. The other circumstance is where a person transfers property other than for value. In this case, it is presumed that the property is held on resulting trust for the transferor of the property. So, for example, where a gift is made, it is presumed the person did not intend to make a gift unless there is a clear intention. So in such circumstances, a resulting trust arises and the transferor retains or takes a share in the beneficial interest. A resulting trust is always for the benefit of the original owner or owners of the property. Okay, so that is now resulting trusts. And there's also this category called implied trust, and some people hold there is no such thing as an implied trust. Some refer to implied trust as including trusts implied by law, such as resulting in constructive trusts. Others suggest that implied trusts are trusts in which there have been no express declarations, such as in Paul and Constance in 1977. The question would not arise but for the use of the term in legislation, such as the Law of Property Act 1925, section 53, subsection 2. Now, I would try and hold an opinion of this yourself. I mean, there is a bit of literature about it. You can see the use of it in the legislation, and you can see how it was used in Paul and Constance. Personally, I think that implied trusts are just general. Is it just a general phrase for a constructive and resulting trust? So, I personally just think that implied trust is just a broader phrase for those trusts that have been implied, such as the constructive and resulting trust. Okay. Now there are other classifications too. So we also have a bare trust, and a bare trust is one where the trustee holds the property for the benefit of an adult absolutely, and this is without any other discretion, other interest or discretion. So in this case, Saunders and Vautier principle will apply, and the beneficiary can claim the trust property at any time. An example of such a trust might be where a solicitor holds client money in its client account. Okay, so a bare trust arises where the trustee holds property on trust for a single, absolutely entitled beneficiary. The beneficiary therefore owns the entire equitable interest in the trust fund. This means that the trustee has no discretion nor any obligation than the stewardship of the trust property on behalf of that beneficiary. The trustee in such a situation is generally referred to as being a nominee, that is, one who holds the property in the name of another. The fixed trust. A fixed trust is one in which there is a certain defined group of beneficiaries and the property is held in specific shares. So a trust of £30,000 held for the benefit of the settlor's two named children in equal shares is a fixed trust. Now, so a fixed trust refers to a situation in which the trustee holds property on trust for a certain defined list of beneficiaries. An example of such a class of beneficiaries would be on trust for my two children, Anna and Bertha, for example. Okay, the fixed nature of the trust refers then to the fixed list of people who can benefit from the trust. In bare and fixed trusts, the trustees have no power to allocate the property other than as provided by the trust instruments. Both may be terminated by the beneficiaries if sui juris, and the trust property transferred to them under the Saunders and Vautier principle. And we looked at the Saunders and Vautier principle in my previous video. So if you don't understand the Saunders and Vautier principle or the concept of being sui juris, go check out that video, and I do explain that in a bit more depth. Okay, and so that's the fixed trust, and then we also have a discretionary trust. So a discretionary trust is one in which the trustees have the discretion to choose which of a defined class or group they choose to apply the income or property of the trust to. For example, a trust of £30,000 to be divided as the trustees see fit between the settlor's children upon the youngest of them reaching the age of 18 is a discretionary trust. So a discretionary trust gives some discretion to the trustees as to the manner in which the property is to be distributed, and also to the people to whom the property is to be distributed to. So for example, suppose a situation in which a settlor has 3 adult children and wishes to require that the trustees use as much of the fund of money as they may think appropriate to help whichever one of the children earns the least money in any given calendar year. So the trustee's role here is more complicated as he'll have to exercise some discretion. A discretionary trust can also be ended under the Saunders and Vautier principles if all the beneficiaries so request, and they are all sui juris. And then the final type of trust I just want to quickly and briefly mention, which will also be talked about in a later video, is the public trust, which is also known as a charitable trust. And these are trusts for the benefit of the public or part of the public, and they are known as charitable trusts, okay? And there are specific rules which apply to charities principally concerned with the idea that a public trust must benefit the public. And before that gets too complicated, I will just say check out my video on charitable and public trust, which will be coming shortly. Okay, so that is a brief overview of the different types of trusts: express trusts, constructive trusts, resulting trusts, and some other classifications of trusts too. And I think that should really help you sort of understand the different types of trusts that are available in equity and trusts. If you have any questions at all about this video, make sure you leave a comment below and I'll get back to you as soon as I can. Don't forget to give this video a like and subscribe to my channel. Thank you very much for watching.